So, as I mentioned, this is the first Lunch GPT, copyright and AI, very hot topic right now. So, what is copyright? So, it's in the Constitution. We've had copyright way back since the beginning, and it even has precursors prior to the Constitution back in the UK, the Statute of Anne, and even further back from that in various social norms. But in the Constitution, it says Congress shall have power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to the respective writings and discoveries. So this covers both copyright and patent law. Both of these are part of the Constitution and have been an idea in US law since the very founding. So to get copyright, it is any expressive work. It has to be an original work, so you can't just copy something from someone else. It has to have enough that's new, and it has to be fixed in a tangible medium. So right now, theoretically, this presentation is recorded because it's in a PowerPoint that's fixed. It's now being recorded as well, so my individual presentation style itself would also theoretically have copyright, probably owned by Zoom under contract law, but nonetheless, it's fixed. Where if I was merely speaking to you in a classroom, the words that I'm saying, they're not fixed. There's probably not much originality in them either, so you couldn't have a copyright over that. The sort of copyrightable works that we think of, some of the ones that are listed here in the Copyright Act, literary works, so books, magazines, that sort of thing, musical works, so all the music that you all like to listen to, dramatic works, so I'm here in New York. If you go to Broadway, it's a dramatic work. Pantomimes, choreographic works, so dances, pictorial, graphical, sculptural works, art, sculptures, that sort of thing, motion pictures and other audiovisual works. So if you go to the movies, that's all copyrightable. Sound recordings, so not only do you have copyright in the musical composition, so the score that you might have, but also in the specific performance of it if it's recorded in a sound recording. So if you used to buy a CD, that CD would have the sound recording aspect, and then architectural work. So buildings, if they're in a particular style and there's enough originality there, those could also be copyrightable. But, and this is a big but, you in no case can have copyright protection over mere ideas, procedures, processes, systems, methods of operation, concepts, or facts. So kind of these like bare structural components for how we communicate and think about things and discuss in the real world that cannot be copyrightable. So for example, the mere idea of a cartoon mouse, that is not copyrightable at all, but Mickey Mouse, or at least some of Mickey Mouse, Steamboat Willie came into the public domain this year. All of that is still copyrighted. It's a specific expression of a cartoon mouse, a la Mickey, compared to me just making a cartoon mouse in a very different style. The idea of a cartoon mouse cannot be copyrightable. And what do you actually get if you end up getting a copyright? Get a little package of exclusive rights. Very importantly here, it's subject to sections 107 to 122. So these are all a panoply of exceptions, but you get the exclusive right to reproduce copyrightable works, prepare derivative works from them, so translation and adaptation, that sort of thing. You get to distribute them. You can perform them publicly. So if you want to perform the music, you can display them publicly. And if it's a sound recording, you can also perform them publicly by means of a digital audio transmission. So why does all this matter to generative AI? There are two main issues that have come up in the world. One is copyrightability of AI outputs. So if a generative AI tool makes an image in response to your prompt, is that copyrightable? And if so, who would get the copyright? And the other is generative AI, which is trained on millions to billions of images and content, much of them being copyrightable or copyrighted. Is that going to be infringement? And if so, what type, who is going to be held responsible, that sort of thing. So on copyrightability side, we've had a lot of different decisions so far. The one that kind of kicked things off and got us lawyer types to start thinking about these issues was Thaler v. Perlmutter. And Stephen Thaler, has tried to register various generative AI created things, both supposedly copyrightable things and patentable things all across the world in various jurisdictions. It's not been very successful, but the United States is one of the jurisdictions where he's tried to do this. And on the copyright side, he tried to register this image here. a recent entrance to paradise, very futuristic, kind of have train tracks going through like a bucolic English countryside. Certainly better art than I could make with my hands, but it's a very interesting piece of art nonetheless. And he tried to register it under the name of Dabus, which is the generative AI tool that he had created. The Copyright Office in 2022 said, no, there is no copyright here because we are thinking purely about humans, and humans are the ones that need the incentives to create while we're giving them this exclusive package of rights. And it cites to a bunch of older cases, going all the way back to a case on photography that was in the Supreme Court in the 1800s, that said that it was solely for man that copyright was existing, and some more recent cases as well that involved other non-human supposed creators. Case involving spiritual beings, where God supposedly dictated to someone what this work should be in the Ninth Circuit in the 1990s. No copyrights to spiritual beings. They don't understand incentives. More recently, we had a case involving a large garden in Chicago. Forces of nature are also not growing due to certain copyrightable incentives. So again, no copyright. And most recently, and maybe most famously, we have the case of Naruto v. Slater involving Naruto the monkey, and this is the famous monkey selfie case. And the monkey happened to pick up a camera or cell phone, take a selfie of itself, and PETA was arguing that this monkey should get the copyright in it because it took the photo. The Ninth Circuit held, no, monkeys don't understand incentives, they are not human, so no copyright for poor Naruto the monkey. And all of this led us to the Copyright Office's decision initially in Thaler saying, basically bringing all these cases together, saying, no, you have to be a human and have human contributions to get a copyright. And Mr. Thaler did not take this lying down. Instead, he went to the district court in DC, filed a lawsuit saying this decision was inaccurate. The district court agreed with the Copyright Office. So again, you can only have a copyright if you are actually a human and have human contributions. And then Mr. Thaler has now appealed that decision to the circuit court. So we'll see if on appeal things change, but so far it seems like this rule is a pretty strong one. But we've had a few subsequent decisions from the Copyright Office that have helped elucidate this a bit more. So the next one, Czar of the Dawn, this is a comic. And Chris Castanova, the artist, ended up actually getting a copyright for this graphic novel and had registered it. So when the Thaler decision came out, posted somewhere on social media, oh, this is so weird. I actually already have a copyright over an AI-generated work. Probably not the smartest move if she wanted to keep the copyright, because then the Copyright Office decided to investigate and figure out what was going on. Whoever the initial reviewer was from the Copyright Office didn't really figure out that here Castanova and Midjourney, that Midjourney is a generative AI tool. And in fact, because Midjourney is a generative AI tool, generative AI was involved in the creation, which complicates things. But unlike the Thaler case, where it was purely generative AI created, here Castanova and Midjourney are co-authors. So they were making things together, there were different contributions. So we have to figure out kind of what could be protectable and what could not be protectable. And going back to Sorry case, Sorry of the Dawn. Eventually, the images were all created by generative AI. So because they were created by generative AI, those particular decisions or those particular images were not protectable. But Castanova made all of the language, all the text that was involved in the comic, so that was protectable. And she also had compiled all the images together. So that aspect, again, was under copyright. The nuance here is that she had made a few small modifications to certain images. So some of them, like Zarya's nose looked a little bit off, or kind of one of the eyes might be a little bit misplaced. So she fixed these aspects. But the Copyright Office said these are too minor. It doesn't meet this originality and creativity threshold that the Copyright Office demands and copyright law demands. The following decision involved this lovely work here. So Midjourney created the initial work on the left, and this was based on 600 plus prompts, allegedly, by the artist. And then the artist added a lot of refinements to result in the work on the right. You may have seen it in the news because it won the Colorado State Fair's Fine Arts competition. So very, very big deal in the fine arts world, supposedly. artists were quite annoyed that an AI-generated work wants competition. And considering that it was supposedly such a great work of art, the artist wanted to get a copyright for it. When he registered, he was very adamant that he put all this work in. This is really more of a tool rather than a machine creating something. And because of this, he should get a full copyright. And here you can see kind of the big differences between the left and the right. So even after he did the 600 plus prompts, he still made a lot of changes to ultimately reach the work on the right. And the Copyright Office said that would have been fine. You could get a copyright on what you added from the left to the right, but you can't get a copyright on everything that generative AI created. Even if you put all these different prompts in, the actual creativity or spark of creation that's happening, that is all from Midjourney, not from the artist. Because he was adamant and ended up not getting a copyright at all in this case. And then the most recent decision involved Surreast. So in this case, the artist, Mr. Sani, uploaded both his image, this photograph of sunset, as well as a picture of Starry Night by Van Gogh, put them into a generative AI system, picked the number that they want to use to correlate the two, and it created this work on the right. Provided both the images, provided theoretically the number of how they should be correlated. Overall, that should be enough, right? Wrong. Copyright Office again said how figure out what that number actually meant. That was all the work of the generative AI system, not Mr. Sani. So fortunately, he does have a copyright over this photograph that he initially took, no photograph over the Starry Night inflected version of that image that's on the right. So that's the copyrightability question. Then we have the AI infringement question, which is maybe the bigger one right now, just because it has such big consequences depending on how it comes out. So there are two components or two times when there might be infringement occurring during the generative AI process. So one is what's at the input layer. So what is a generative AI system being trained on? And here it's ingesting a bunch of different works, millions and billions of them. Many of them are copyrightable or copyrighted with the Copyright Office. And is the mere training of an AI system on all this work, is that an infringement? That is question one. Second one is at the output layer. So these generative AI systems are also creating outputs like the ones we saw on the prior slides. Are these individual outputs infringing any prior copyrighted work? So input side infringement at the training or output side infringement. The big question surrounding both of these is fair use. And usually if anyone knows anything about copyright, it's the fair use exception. And fair use uses these four theoretically non-exclusive, but usually exclusive factors to try to figure out whether these are the sort of societally beneficial purposes that we would like to have and allow these uses of copyrighted works. In particular, we look to the first factor and the fourth factor. So the first factor, the transformativeness of it, or how different it is if it's for a different purpose than the original. And the fourth factor, what is its effect on the potential market for a copyrighted work? So we're now really considering whether the training is a proper fair use and if a particular output is a fair use as well. Most of the cases right now are focused on the input side. Training, so are these millions to billions of images that are being copied for training purposes or being trained on, are these actually infringements or are they fair use? And there are a bunch of cases that have been filed at this point, basically 20 of them, but I'll flag three of the biggest ones. So we have Getty Images, which is in the District of Delaware. So Getty Images, as you may know, large stock photography and image licensor online. So if you want an image for something, get Getty Images. They allege that a lot of their images were copied for the purpose of training. In their complaint, they have several kind of graphic images that are very similar to images that are available on their platform. And how they figured out that their images were being copied are that their watermark, so the Getty Images watermark that usually appears in the images, it actually showed up in a lot of these images that were coming out of the AI tool. So not great. It also added some related trademark infringement claims. The Getty Images case hasn't really gone anywhere so far because of jurisdictional questions. So it's not quite clear where the training happened for the AI tool. which could impact the jurisdiction, whether it should be in the District of Delaware, whether it should be in California. There's a simultaneous or parallel case that's in the UK as well. So that one, not a ton of movement right now, but some big implications and very high-level attorneys when that eventually happens. Next, we have Authors Guild. So Authors Guild, big representative for authors, surprise, surprise. And they filed a lawsuit just a few months ago in the Southern District of New York, alleging that all these works by famous authors, such as George R. R. Martin, had been ingested into this training data, and that the training system now was reproducing things based on this data. We'll see where that one goes. That one had a lot of commentators, a lot of lawyers in the space thought that this one has legs and could potentially reach a very favorable decision. Interestingly, the Second Circuit, where SCMY is located, has a lot of the biggest non-expressive use, fair use cases before, such as Google Books. So this could be a particularly interesting case. And then finally, New York Times, shortly before the new year, decided to sue OpenAI after its negotiations for a license fee broke down. So this one also considered to be quite interesting. There are examples in the complaint of very similar outputs to New York Times articles. Of course, if you're asking the tool for certain outputs, it's more likely than not to give certain things, but could still be infringing and not a fair use. So we'll see where that one goes. If you are interested in this type of litigation, a professor who's at Chicago Kent keeps a running list at chatgptiseatingtheworld.com. Great catchy name. So feel free to follow that and kind of see what's going on. And so just as an overview, here are kind of the questions that we are facing on the infringement side. So first, on the training side, is it a fair use or is it infringing? If it is infringing, well, this means that you're likely going to be held liable for infringing millions of copyrights with statutory damages that could be quite staggeringly high. So anyone except for kind of the largest tech companies would effectively be foreclosed from working in the generative AI space, at least without using open source materials. If it is fair use, great. Question one is done, but then we have a second question on the individual outputs. Will this be infringing or not? The risk to generative AI as an overall tool is much less because it's just on an individualized basis rather than a system-wide basis, but we still have to figure that out. Most scholars have concluded, both on the computer science and legal side, that at least a few outputs will probably be infringing. I mean, this might be 20 of them out of a million, but there'll still be some infringements that will occur occasionally. And then there's this final question: who should be liable for the copyright infringement when that occurs? Courts have not even remotely started thinking about this third question. They're still focused on the first one, and we'll probably eventually get there in the years to come. So that is a working overview. I will stop the